Good afternoon, everybody. Welcome to our webinar today, a deep dive into key build, what's in path and what's next. This webinar is being hosted by APA Florida, and it's worth 1.5 CM to one loss CM. Thank you everyone for joining us today because this is the first of a series of webinars that's going to be done today at the conference and October 28th, where we're going to take a closer look at the various pieces of legislation that have passed this past year. With me today are Zachary Good from TG Law, David Cruz from Florida League of Cities, and Anna Grace DePaolo from Mets Hudson and Dalton. A little background on myself. I'm the technical vice president for the Corradino Group. My background is transportation, economic development, and general comprehensive plan and land use planning. And I previously served as community development director for the North Miami Beach, city of North Miami Beach. Anna Grace is a policy advisor who joined Mets Hudson and Dalton after serving as a policy analyst for the Florida House Transportation and Modal Subcommittee. Previously, she worked at the Florida Chamber of Commerce, where she was the policy director for town education and infrastructure. As the policy director, Anna Grape formulated policy and legislative strategy for early learning, K-12 education, higher education, workforce, transportation, water, and energy issues on behalf of the Florida business community. She was named a Florida Politics Rising Star for the class of 2022. Anna Grace is a graduate of FSU and the Honors College, which she earned undergraduate degrees in political science and history. With us also today is David Cruz. David serves as the Deputy General Counsel and Legislative Counsel for the Florida League of Cities, where he's worked for the past 13 years. In this role, he advocates on behalf of Florida cities before the state legislature and provides legal counsel on a wide range of municipal issues. Mr. Cruz also serves as legal counsel to several intergovernmental entities affiliated with the League of Cities, including the Florida Municipal Investment Trust, the Florida Municipal Pension Trust Fund, and the Florida Municipal Loan Council. He holds a Juris Doctorate from Barry University School of Law and a Bachelor of Arts in International Relations and Political Science from FIU. Mr. Cruz is board certified by the Board of Bar in City, County, and Local Government Law. Before joining the League, he served as the legislative aide to former Lieutenant Governor Carlos Lopez Quintana. Last but not least is Zachary Good. Zach is a Florida attorney with deep expertise in local government law, focusing on land use, zoning, contracts, and public policy. His background includes working directly within city government, giving him first-hand experience in the inner workings of municipal processes, regulatory compliance, and public communication. Before becoming a lawyer, Zach served as the Director of Communications and Marketing for the City of Homestead, where he helped lead strategic messaging and policy initiatives, an experience that shaped his practical approach to public sector legal challenges. At TG Law, Zach supports municipalities, developers, and agencies with land use applications, zoning matters, procurement procedures, bond referendums, and local government compliance. His cross-functional understanding of both legal and operational issues makes him a trusted advisor in Florida and public and private sectors. Now, before we begin, I want to note to everyone that we did prepare some documents and the slide can be downloaded. You can check your screen on the little app on the side where it says more. Underneath there will probably be three little dots and say materials. You'll find the presentations and some items in there that will help you follow along as we run through our overview of the legislative session. So this session this year, it ran from March 4th to June 16th. It was a little extended because they ran into having to go work with the budget a little bit more, and so you'll find that there was quite a bit of discussion throughout the legislature this session, with a total of 1,982 bills of all types being filed. 234 of those were passed by both chambers. This year's budget represents a $3.8 billion reduction from the previous year and reduces the size of state government by nearly 2,000 positions. Anna Grace will talk about that more in a little bit. On your behalf, APA Florida tracked 237 planning-related bills, and we're happy to discuss more in depth about the ones that passed today, the implications, and also as we go through this webinar, be on the lookout for how we're connecting between various pieces of legislation too, because they do have a lot of these have an effect on each other. Now, legislation that didn't quite make it to the finish line ranged everywhere from adaptive reuse of land to very surprisingly to us, housing SB 184, which we believe will be coming back next year. As many of these are we've seen from past years, they may not make it through. Items like the agricultural enclaves bill that has been previously discussed at the local section overviewed during the session and so forth, as well as the aspect of affordable housing as well. However, there are some great victories for the protection of Florida's natural resources. In particular, we were really proud to be advocates for HB 209 state land management. This bill creates the State Park Preservation Act, and it really requires state parks and preserves to be managed for conservation-based and recreational uses and associated facilities. There is quite a bit of protection there, including on public information and requiring land management planning to be a little bit more intense for our natural resources. In addition, you find that the legislature passed HB 1143, which prohibits the drilling, exploration, or production of oil, gas, or other petroleum product within 10 miles of a national estuarine research reserve in counties designated as rural areas of opportunity, and requires the Department of Environment Protection to apply a balancing test when considering a permit for oil or gas activities in areas within 1 mile inland of the coast or other bodies of water. This time, I'd like to turn it over to Anna Grace to provide a budget recap for folks.
Thank you, Eddie. And before I start, I'd just like to introduce my colleague, Doug Bell, who is also on the call with me today. He and I joined the lobby team for APA Florida this year with Lester Abinger, and so we have tracked these bills and followed the budget. And while we're not going to provide the policy deep dive today, I'm going to provide a quick budget recap before you all start. As Eddie noted, the legislature wrapped up on June 16th this year. The governor signed the budget on June 30th. The budget total was $117.4 billion, which was about $10 million smaller than the governor's recommended budget and about $500 million smaller than the budget passed by the legislature. He vetoed $567 million in projects, and I would like to highlight for you all part of a veto that is in addition to the $567 million is the $2 million from the Florida Wildlife Corridor. And that might sound bad, but it actually protects the funding of the Florida Wildlife Corridor. The legislature had proposed a plan to divert that funding and put it back into general revenue. The governor's veto protects that money to be used for land acquisition in the future. Eddie, you can go to the next slide. Eddie, next slide. Thank you. I'd just like to highlight a few things on this slide. We're not going to go deep into all of it, but the budget includes about $1.4 billion for Everglades restoration, and this is in line with the governor's goal to fund it at $3.5 billion in the course of his 4 years. This brings the total to $4.6 billion so far, and there's one more year to go. The budget also includes $436 million in legislator projects, which is about 315 projects. I would like to highlight that the governor's veto of the $200 million actually helps that this year's state budget only includes $18 million for the Florida Forever program. The governor recommended $100 million. That's down from $229 million that was funded last year. So that extra funds that are protected will help the $18 million for Florida Forever. The budget also funds $250 million for the Rural and Family Lands Protection Program. That's an increase in $100 million, which is a big investment in protecting the farmland and adding to Florida's wildlife corridor. On this slide, you'll see that Ship and Sail were fully funded. Hometown Heroes was funded at $50 million. It's down from $100 million, but the fund actually was narrowed, and it narrowed the requirements in the budget in some proviso language. I wanted to note in the cultural and museum grants, while it was funded at 24.5 million, there's actually a $1 million grant that opened last week to celebrate the nation's 250th birthday celebration. So if your local government or you're an organization that wants to receive grant money to highlight the 250th anniversary, that is now open for you to apply through the Department of State. Next slide, Eddie. The last thing I'll talk about is there's some little implementing language that was in the budget this year that has a big impact on local governments, and that is the DOGE authority of OPB. And you all have probably heard about these as the letters have gone out. And the Office of Policy and Budget received the authority to do this through the budget. So it allows them for 1 year to kind of audit local governments for their spending. They're looking for any inconsistencies with state law, overspending, waste, fraud, or duplicative functions. They can access personnel, the physical premise, and data systems. And we've seen this last week. The governor and our new CFO Blaise Ngolia, announced that they are auditing Gainesville, Broward, and Manatee County. And then we saw this morning that Orange County has been added to that list. And cities who fail to comply, OPB can enforce a $1,000 fine per day. And Eddie, if you go to the next slide, you all can see what these letters look like that have been sent to local governments. And that's all I have on the budget. I wanted to keep it short so you all can get a full policy dive with Eddie, Dave, and Zach.
Thank you, Anna Grace. And now into the actual bill. So before we go into the deep dives, really wanted to tell you, give you guys an overview of how we approach how the presentation will go today. And we have a number of bills that our planners across the state have really told us, hey, we want to make sure you cover these a bit more, ranging from SB 180 to 1730, 108, 1080, and so forth. We're not going to cover every single bill today. That's why we have a series, because there's so many pieces of legislation that have passed. But what we'll do is, for the ones that we'll cover today, starting with SB 180, we'll tell you what the piece of legislation does, the implication for local government, and I'll cover then for each one the planning and administrative toolbox that hopefully will give you some food for thought, particularly for our practicing planners at the county and municipal government level. And with that, I'd like to turn it over first to Zach to talk about what the law does for SB 180.
Thank you so much, Eddie. So good afternoon, everyone. In my world, SB 180 has been a major feature for our clients, both on the public, municipal, and county governments, as well as on the private side, the impacts for our private sector folks in the development community. So SB 180 is titled Emergencies and contains a lot of language that deals with emergency functions and recovery after emergencies. I'm going to first take a pretty brief overview of those emergency impacts and what the law does as far as emergency management, and then spend a little bit longer as we get into the planning side of things and the impacts for our planners in the audience. So the first thing this does is local governments are now required under law to ensure that their emergency declarations and orders do not conflict with state emergency management actions or directives. If a local order is found inconsistent with a state emergency declaration, it is subject to being nullified by the state. And local emergency declarations have to meet a stricter procedural and documentation requirement which includes justification standards and notification timelines for the public. Local governments have to provide the state with additional information and justification related to these emergency measures, which includes impacts on developments. So that's where you all may see, requests for information from your city managers or your emergency managers. The SB 180 also requires that contracts and expenditures made under emergency declarations be posted online and reported to the legislature. SB 180 further establishes timelines and requirements for reports on emergency-related spending, assets, and reimbursements. There is a provision that revises hurricane shelter funding priorities to target non-school buildings in shelter deficit regions. And the legislation provides that special needs registration information is to be shared by state agencies and housing providers, and to allow caregivers and dependents to stay together in special needs shelters, which is a big change from previous practice. And on the next slide, we will start to dive in a little bit to what the impacts on land use regulations and development are. So SB 180 prohibits counties and municipalities impacted by a hurricane that is within 100 miles of the storm tract from enacting moratoria on construction, redevelopment, or more restrictive land use amendments for 1 year post landfall. This is a prospective piece of the bill going from the date it was enacted into law moving forward. And then we have the counties and municipalities affected by hurricanes Debby, Helene, and Milton are prohibited from imposing moratoria for properties damaged by these storms or adopting more restrictive land use regulations or permitting procedures until October 1st, 2027, and retroactively from August 1st, 2024. This is very important because I'm sure most of you and most of your organizations have done a lot since August 1st of 2024. So there's going to be a chance that some of the actions that were taken may be considered as more restrictive land use regulations or permitting procedures. And why that is important is because legal challenges can be filed under the bill. There's a legal cause of action created under the bill to to block and to provide for the repeal of these actions. So the way that works practically is a business or resident who is impacted by these regulations can notify the city or county who has enacted such a regulation or procedure, and there is a time period, 14 days, in which the government has the option to consider whether it will repeal the action of its own volition, in which case you would have to either actually repeal the ordinance or resolution that enacts these changes, or at a minimum provide notice of intent to repeal, and then from that you'd have an additional 14 days in which to repeal. That is important because in the event that the local government does not decide to repeal the regulation or procedure, the aggrieved party can move forward and bring an action in court against the city or the county that has enacted the regulation procedure. And if it is found that this regulation or procedure is in fact contrary to the intent of SB 180 of this law, that there would be attorney's fees for the prevailing party. So the local government would be, in addition to its own defense costs, responsible for the costs of the individual that has brought the suit. So in addition, local governments that are participating in National Flood Insurance Program cannot enforce rules that count cumulative repairs or improvements over time towards substantial improvement thresholds. This is likely a major change for many governments um, across the state. And another important piece is that local governments and special districts cannot impose impact fees on replacement structures, so a structure that was knocked down during a storm, unless the new structure significantly increases demand on public facilities. And as we move on to the next slide, I also want to flag for those of you um, listening today that if you have any questions, you can go ahead and type those in the chat, and we'll do our best to start answering those as the session progresses. Um, Now, the final piece of what the law does is that local governments can no longer rely on emergency powers to justify temporary land use restrictions, such as development moratoria, without facing state oversight or override. And development moratoria tied to emergency declarations like infrastructure strain, storm recovery, may be invalidated if they conflict with a statewide emergency directive. This is very important. Further, local governments imposing moratoria or halting development may face legal challenges, as I talked about on the previous slide, from developers or property owners that are asserting this preemption under SB 180, which is one of the major concerns for local governments. So really, what does this mean for local governments? Boiled down very simply, it limits local regulatory power post-disaster, even for safety or planning concerns. It may force acceptance of redevelopment plans that are inconsistent with local recovery or resiliency goals. Um, it reduces the ability to pause development while infrastructure or environmental impacts are assessed. And it could create a conflict between local zoning or hazard mitigation plans. So this sounds pretty scary, obviously, to some local governments. But I think the key is going to be in what Eddie is going to bring up for you next, in exactly how you as planners and local government professionals can deal with this.
Thank you, Zach. So if I was still a community development director, I think the first thing the city manager is going to tell me is, all right, Ed, we need to develop protocol for expedited permitting and fee waiver systems, pretty standard items that you see reacting to this. I should be working with building official and my public information officer or communications director, depending on what you have at the city, on posting of emergency information, including recovery guides that are mandated for May 1st of each year, and of course coordinate with the flood information that's needed and making sure that the community knows about this information as well. But I think what we're hearing from our planners is that really more concerned about the restrictions found in Section 18 and Section 28 because of the preemptive nature in these texts. And we want to discuss more about this and that the key here from a planning standpoint to think about what is actually more restrictive and burdensome. That's the key word here. So as planners, we should be thinking about the rule defining something already in place or a clarification and not really a brand new rule. For example, paint colors. I'm changing the paint color palette. I'm not creating a new rule. I'm clarifying it. But then you can, take this from a standpoint of a higher order standpoint. And you have to look at your existing comprehensive plan and private legislation on these higher level functions and rules. I would also tell planner to review the record for variances and determine if rule changes to occur to issues. Because sometimes just because something looks like it's more restrictive on its face doesn't mean it actually is when you think about it further. Um, one critical thing to do here is to make sure you put aside a file folder of all the development orders and amendments in August 1st and review them as needed because there's going to be different challenges come at different times, and this doesn't only just affect legislation you pass, but potential for going back and looking at these site plans that have been approved. And in cases where the Well, we think about it. There are difference between different approval processes, right? Building approvals are different than zoning, and building approvals are rooted in the Florida Building Code, right? So they're distinct from zoning and planning level approvals. Think about how that can be used to your advantage because you can really tell an applicant, well, we could change the zoning rules back, but the building code said you can't build it, so we could approve it from the zoning, you still can't build it, and maybe they'll back off. In some cases, I've already encountered that that's actually the case there. But in cases where the LDC and LDR were the only amended portion, consider consistency and root basis in the comprehensive plan. And when the comprehensive plan was passed, was it before August 1st? Of 2024. Did the repeal of the LDR and LDC regulation render the code less or completely inconsistent? It's a really critical question. And remember, folks, that the comprehensive plan takes precedence. So, you find that repealing the rule that creates that inconsistency, there's certainly a conflict there that you should explore a little bit further. You can produce a new ordinances. SB 180 does not prevent this. But when you do so moving forward, maybe consider characteristics using incentive and bonus programs, and consider words like define and clarifying the thought processes for development of new ordinances. Consider if it makes sense to clarify it as well if something was originally open-ended. If you already changed the rule, consider reverse to that argument. Clarifying an open-ended rule may seem restrictive, but may actually be less restrictive if you're narrowing the scope. And we'll also work with city attorneys because zoning in progress and moratoriums, which are also restricted here, are different processes. And this may cause some folks to wait to see if the rules are better for them. Something I would do in my practice, if I were you, is consider case by case release mechanisms and laying out the appeal process because that causes whether or not these requests are going to be ripe and structure your staff reports accordingly. Um, and lastly, consider the time frame of repeal, 14 days versus public noticing requirement. State 5 and 7 days. Maybe your local government has a 10-day rule, as I have seen with some local governments. So if the time frame for appeal is 14 days, and you have to advertise, and it takes 2 days to get to the paper to advertise. It kind of gives you only a 1 to 2 day time frame to really think about whether you appeal or you hold your ground on something. So it's really important to think about these things in advance and be ready and prepared to discuss these items further. Next up is SB 1730, which is the update to a Live Local Act. And for that, I'm going to turn it over to David.
Thanks, Eddie. And one thing I would add on Senate Bill 180 is that, it's my understanding that a legal challenge is forthcoming. I've heard this from some city attorneys, and it sounds like the law firm of Wise Sirota is going to be spearheading that. It's not something that the Florida League of Cities is directly involved in, but it certainly sounds like Senate Bill 180 will likely get challenged. And so it's going to be an evolving issue and something that your cities and counties will certainly want to stay in tune with as that issue continues to evolve moving forward. So with that said, let me jump right into Senate Bill 1730. And for those of you keeping track at home, this is the third session in a row that the Florida's Live Local Act has been amended. And so given that it's the third time that we've delved into this bill and amended the law yet again, I just wanted to give a little bit of context as to what the issues were and why the changes were proposed and ultimately passed in Senate Bill 1730. And so as you recall, the Live Local Act was originally passed to try to accelerate workforce housing, near transit, and near jobs for our city and county residents. Certainly in Florida, there is a shortage of affordable workforce housing. And so the goal of the bill was try to address those issues, and it largely does that by preempting local zoning for multifamily and commercial and industrial parcels. And, I thought this tidbit here is interesting, and I just wanted to share. I want to thank Susan Trevarthen with the Wise Sirota firm for actually making me aware that these statistics were even available. But we hear so much about the Live Local Act, and yet we don't necessarily hear how many projects are being proposed under the Live Local Act. And so the Florida Housing Coalition released this data as of March of this year. There has been a total of 108 6 proposed live local projects in all of Florida, and 80% of those were on commercially zoned land. And if you look at the breakdown, you could see that Miami, the city of Miami, had 29 of those. 13 of those were in Miami-Dade County. Miami Beach had 10. Hillsborough had 7. Fort Lauderdale had 5. And then Cape Coral, Orlando, and Osceola, each of those had 3. And so it's interesting to see where throughout the state these projects are being proposed. And the last interesting tidbit here that Susan also made me aware of is that despite all of these projects being proposed in the last 3 years, only one project has successfully broken ground, and that's the project of Beacon Hill in Miami-Dade County. So interestingly enough, we've had a lot of legislative developments on this, but yet it seems like the actual projects are lagging behind. So with that said, let's jump into the next slide. So why exactly did we have to revisit this bill yet again and amend the legislation again? And I think what really happened was that you had a host of unanswered questions that had been brewing since the bill's passage, and you saw some of these unanswered questions kind of come to the forefront in a couple of informal attorney general opinions. One of them was by Dania Beach, where they were trying to question, what does mixed use zoning mean? You had another one done in 2024 that was issued to Representative Lopez, where they were trying to delve into what does Orlando's mixed MXD2 zoning mean, and if that would open it up to a live local project. You had questions about whether live local applied to PUDs, and you had questions about whether live local could apply to a golf course. If that was a commercially zoned area, is the golf course open to live local development? And so you had a lot of questions building in the background and throughout last year's summer, where legislators and stakeholders were proposing solutions and answers to these questions, which then brings us into Senate Bill 1730 and what the bill does. So with that, we'll go to the next slide, Eddie. And so I thought a good way to kind of talk about what the bill does is to kind of do a deep dive into where now live local projects may be located. And I think that was one of the primary driving factors within the bill, was to bring clarity as to where these bills can be located. And one of the first things the bill does is to open up live local developments in a religiously zoned parcel, or essentially yes in God's backyard, or YIGB. So it authorizes but does not require a city or a county to approve an affordable housing project on any parcel that is owned by a religious institution, as long as 10% of those units are made affordable. So that is an optional element, and so now live local projects can be located on religiously owned areas. Then it opened up what is flexibly zoned areas. Live local projects can now be located in portions that are flexibly zoned areas permitted for commercial, industrial, or mixed use. And the local governments may not require a density transfer, an amendment to a development of regional impact, or more than 10% non-residential square footage in the case of mixed-use residential projects. So here on the next slide, let me get into a couple of other areas that the bill brings some clarity as to where these projects can be located. The answer as to whether a live local project could be located within a PUD is answered in this bill. And so, yes, a live local project can be located in a PUD. It goes into a little bit of defining what a commercial property is, and it really focuses in on the use of the property rather than the actual zoning category. And so the property, in order for it to be available to be located for a live local project, it must be zoned by right. So not a variance, not a waiver. It must involve, then this is where we start to look at the commercial activity. It must involve sales, rental, service-related commercial activity. So we're talking restaurants, offices, hotels, entertainment. But what it does not include, and I think this is really important, is it specifically exempts home-based businesses, vacation rentals, and then recreational uses. So for example, the golf course or a pool at a community that has already been developed, you cannot then go back in and open up that golf course into a live local project. That's some clarity that's been brought into by this bill. The bill then further defined industrial uses, and you could see there what the definition includes. Again, we're really looking at the activities. And then we talk about mixed use, and the bill brings some clarity into mixed use. But it's specifically under mixed use, it's going to exclude accessory, temporary, or incidental, and again, recreational uses. And so the focus, is really on the use of the property rather than what the property is called in their zoning. Lastly, the bill opens up adjacent properties now for development. This is an optional element if the local government agrees. An adjacent property to a Live Local Act could be added on, and they could now use that for a Live Local project as well. So with that said, let's go into the next slide and talk about where a Live Local Act project cannot be located. Under the current law, we already had a little bit of clarity, so we couldn't have any Live Local projects in an airport impacted area, and we couldn't have them in recreational and commercial working waterfront zoned properties. Then the bill this session went further and said no Live Local projects in the Wekiva study area, no Live Local projects in the Everglades protection area, and like I mentioned earlier, no projects in golf courses, pools, tennis courts, and other recreational areas that are considered a commercial use. With that said, let's go to the next slide, and I'll start hitting on some of the details of the bill. One of the first of which is the issue of parking. And, Florida is unique in the sense that it doesn't have mass transit like a lot of other states do, but Live Local tries to give developers some bonuses for parking. And so this has now been further incorporated into the bill. Specifically, the bill says that a city and a county must reduce required parking by 15% of the development if the development is located near a transit stop that is accessible or within half a mile of a defined major transportation hub, or a development has available parking within 600 feet. With that, let's go to the next slide, Eddie. And then I want to just talk about moratorium. There's been a lot of discussion about this, and I think there was maybe a couple of local government jurisdictions that had done moratorias initially when Live Local first came out. The legislature now wanted to make it absolutely clear that you cannot do a moratorium on Live Local projects. And there's some specific criteria that goes into that, but there are some exceptions. You could do one that if it's an ordinance-based moratorium for up to 90 days in a 3-year period, if an assessment on affordable housing need and the 5-year projection for affordable housing has been prepared, and then further it went on to specify that you can do moratoriums for a couple of things. And those couple of things are, for example, if there's a stormwater or flood management issue going on with your jurisdiction, if the supply of water, for example, that's happening in Zephyr Hills, there's not enough water to support the development, you could do a moratorium. Or you could do a moratorium if the sewer systems are not capable of supporting new development. So those are examples where moratorium would still be allowed, but these would be applying to all residential properties and not just Live Local projects. With that said, we'll go to the next slide. And just want to mention that there was some issues dealing with historic properties, a lot of discussion in the legislature about Miami Beach specifically, and ultimately we landed on these set of rules for historic properties. Essentially, we're going to go back and look to see if the property in question is located within a historic district listed in the National Register for Historic Places, and it had to be listed on there prior to January of 2000. And then we're going to go ahead and say that if it is listed on there, you can go ahead and build, but you're going to limit height more than you would a normal Live Local project. And the height limitation is going to be allowed as of July 1st of 2023 for a commercial residential building within 3/4 of a mile from that site, or 3 stories, whichever is higher. As far as demolition goes, you're going to have to administratively approve the demolition of the historic building. And then there is some provisions dealing with our architectural design. The local government's going to be able to set some standards for the design of the building, as long as they're not going to impact the height, the floor area ratio, or the density. So, it's pretty clear here that the floor area ratio has been preempted. There was a little bit of a clarity that was brought into that discussion as well. And we're looking also, the bill places limits on the lot area ratio as well now. That's been preempted as well. With that, we'll go to the next slide. And just to talk about the implications for local governments, especially from the city attorney side of things, you certainly want to start thinking about some of the attorney's fee provisions that were put into this bill. The bill goes on and creates a civil action that is new, and so it says that the court actually has to expedite the hearing of one of these live local violations, and that they're able to award reasonable attorney's fees and costs to the prevailing party, up to $250,000, and no fees on fees. And then it creates a brand new cause of action for land use discrimination. Essentially, it's going to be unlawful to discriminate in land use decisions or permitting based on whether the development is an affordable housing project. So certainly one to keep a look at as this issue continues to evolve. With that, Eddie, I'll turn it over to you for best practices.
Thank you, David. Generally, from a best practice standpoint, you want to really hone in on your GIS and zoning data management, maintaining separate files specifically for these regulations, just because you're going to have other ones that update over time. What this act does, it really does peg things to July 1st or to whichever is the greater, or your current regulation, whichever is greater. So I would just, do data management that include columns, including increases, so that you have everything in one place and easy to really turn these out, because Live Local Act applications have a very short turnaround review time frame, even though they're administrative. I will also identify single family residential districts in any areas with 25 plus contiguous single family homes, and also maintain historic district files with contributing structures as well as your national register site in that same GIS database. Importantly, now that we have YIGB, also do that as separately. It's important to really realize that the way it's written, it's not just whether the house of worship is on that particular parcel. If it's adjacent to that parcel, think about, even if it would have a unit title, even if it didn't, it still actually technically counts. So you want to map that out in its entirety, so you know which parcels are being affected within your community. From a design and planning consideration standpoint, one of the biggest things that when Live Local Act came in, that I really struggled with was, if I had a Live Local Act application come in an industrial area, how do I have certain housing design standards when you normally don't have those design standards within that zone? When we think about houses of worship, for example, they're in a lot of different zones. They're in civic, they're in institutional, sometimes they're allowed in residential, industrial, commercial, and these don't necessarily have regulations regarding the design or function, the character, either in the comprehensive plan and land development regulations. So it gives a big question mark for planners on how you're actually going to evaluate this stuff. And so, you coordinate within this area. Also, be mindful of the restrictive and burdensome aspect of SB 180, and apply compatibility standards to avoid designs that are out of sync with the neighborhood when these items inevitably come in. Also, consider amending standards to ensure quality housing, and perhaps use incentives to promote desirable development as well, considering the effect of SB 180 and what is considered more restrictive and burdensome. Before our parking reduction goal, something that we just did with one of our clients is to define transit stop and major transportation hub. Without doing that, it's a transit stop, your local circulator, it's your regional bus system. You run the gamut of what transit actually is. And if the intent is to reduce parking, then you want to make sure that it works in a way for your community where it's linked to that transit as a reason. And your definition should consider the service, the headway, the accessibility. And there's not a really big distinction between a transit stop and a major transportation hub, which may have multiple modes of transportation converging, park and ride is different than your your standard just regular bus stop on the street, right? I would also require all this local applications to provide a plan sheet, and we'll go over this a little bit in 1080 and linking to 1080 and the minimum requirement for applications there, and have them show you all the transit stops, the distance to the building entrances and egresses, and how safe pedestrian-friendly means such as sidewalks, bike paths, etc., are provided or will be provided. Um, and while a city may not require available parking be compensated under the drill, it could consider incentives and other rules that provide for transit as related to parking. Um, as far as YIGBY, I know there's been questions asked me of how it applies to Fair Housing Act that generally provides against facilitation being part of housing or tenant requirements, so there's no concern really there. Uh, again, to just review the underlying zoning district as well. Similarly, think through your PUDs and DRI for that flexible zoning now. You don't need to amend the DRI to provide for live local housing, but it also doesn't require transfer of density, which may be problematic as some districts have certain residential unit threshold or basket of rights system. And if you have those type of system within your code, you really have to think through what these extra units mean. Do you count against that? Or you count it as part of it? Considering historic districts and structures, what we didn't say was you can still enforce the architectural design requirements. And I want to note that within Florida, there's a critical distinction between having something in the National Register of Historic Places versus the Florida Master Site file. And that's a really critical distinction that local planners should have in their consideration for this. In addition, the act provides for demolition, approval of demolition for existing structure without quasi judicial or administrative board approval if the proposed demolition otherwise complies with all state and local regulations. We'll discuss SB 582 in a little bit later, but you should pay attention during that and see where the linkages are and establish guidelines for your building department on demolition permit reviews if for historical structures if this is concerned from where you are. Note that from a mixed use standpoint, the changes also affect the cap on mixed use percentages, which in particular affect TODs more than others. And this is separate from the 65% minimum residential use requirement that you find. And lastly, I think David covered everything with the moratoria. From an administrative standpoint, about the community development director, I would think carefully about the budget implication and put that back to the city manager's office and the commission, and whenever they want to propose a moratorium. And again, note the difference between a moratorium and a zoning in progress, and work with your city attorney's office regarding those. And with that, I know we're covering a lot of heavy data in a short amount of time. I'd like to ask Zach to take us through SB 1080.
Thank you, Eddie. So SB 1080 sets is titled Local Government Land Regulations, and this sets restrictions and penalties related to the development permit process for counties and municipalities. It sets firm timelines that our local governments have to abide by. It introduces the concept of an application fee refund if the timeframes prescribed by statute are missed on a sliding scale all the way up to 100%. And it limits your local requests for information to a maximum of 3 rounds. Also amends regulations around impact fees, school district fees, and comprehensive plan amendments, and provides for statewide consistency in the permit processing and impact fee changes as far as process. So I'll talk a little bit on those pieces in some greater detail as it comes to the timeframes for development applications. So a local government must confirm receipt of applications within 5 business days. A review for completeness and a response, whether it is complete or incomplete, must be provided within 30 days. There must be an approval or denial completed within 120 days if no hearing is required, and within 180 days if a quasi-judicial or public hearing is required. This timeline does get adjusted, gets reset, if there is a substantive change initiated by the applicant. So that's defined as a change that alters density, intensity, or square footage by 15% or more. Again, as mentioned, the refunds for missed deadlines are on a sliding scale from 10% all the way up to 100% of the application fee, depending on which deadline you miss. The limitation on additional requests for information is limited to 3 rounds, 3 requests for additional information per application, unless that is waived by the applicant. And a agency response is, of course, required within those timeframes for each round. Local governments are also required to clearly state if state or federal permits are required or may be required as part of an application for development. As far as the school impact fees, there's a restriction on alternative school fees. So school districts cannot impose alternative impact fees unless they comply with standards provided within the bill. And the district bears the burden of proof in any legal challenge. There are some pieces related to building permits and the building permit fees. So as you look at your use of building permit fees, you're falling under the existing provisions that have been tightened up a little bit as far as revenues only being used for building code enforcement and related permit processing functions, and that it cannot be used for zoning, public information, or unrelated administrative tasks, and that unused balances must be rebated or used for fee reductions. There is a change on impact fee inaction. So there has to be a 2/3 vote of your local government for for an increase, and there's a 5-year look back that no increase beyond standard limits can be enacted if there is a change that has occurred if no fee change has occurred in the past 5 years. As far as comprehensive plan amendments, a timely adoption is required. So if you have not adopted a comprehensive plan amendment within 180 days after receiving agency comments, amendments are considered withdrawn. Once a second hearing occurs, local governments must adopt the amendment within 180 days, and final amendments must be transmitted within 30 working days of adoption. So that's kind of the major implications and what this actually does for local governments. This is really a lot about timing and process, which, and of course, as we've seen with some of our other bills this session, this is going to require greater internal efficiency. There is going to be some limit on local autonomy in the adjustment of impact fees, which shifts, more of that power to the state. And local governments could face revenue uncertainty as far as these refunds and reduced discretion in the managing of planning and infrastructure cost recovery. Now I'll turn it over to Eddie to talk to you about the practical ways that you can deal with this.
Right. So there's a lot a lot to digest here, and it's really just making sure you have procedures in place that consider calendar function. And since they're requesting minimum information anyway, I would just consider putting in new deadline for folks, including information like what constitutes a substantial change, specifically that 15% noted in the code, and be very careful when you're in correspondence. I would suggest you only deem an application complete in writing after you complete the review, including the DRC process. Um, DAC noted the aspect of comprehensive plans and plan to work with the city attorneys and city clerks to make sure that any tabled items are tracked for 180 days. And importantly, consider extending the date when you need to workshop the item instead of scheduling the second reading. It's really important to note that the 30-day time frame affects when the plan takes effect, and the state is required to file any objection in 5 working days. So if you want something to go forward really, really quickly, they changed it from a 10-day reporting to a 30-day reporting period for when you have to get the stuff over. But remember that, your plans don't take effect in the 31 days after the state land planning agency notifies the local government. So if you submit this 30 days in, then your plan takes effect 61 days after that. So just be mindful, especially you're under pressure to get certain rules into place for your comprehensive plan. There are aspects in this aspect about school concurrency, and they really just note references to rational nexus and proportion, known as the Nolan-Dolan rules. Um, there are also effects on the impact fees. For time purposes, I'll let you guys go through the slides in the handout as we move towards SB 180, Administrative Procedures. And to that, I'm going to turn it over to David.
Thank you, Eddie. And, Senate Bill 108 makes substantial revisions to Florida's Administrative and Procedures Act, which is essentially Chapter 120. It's changing the rulemaking procedures, the timelines, the requirements, how public input process is done, are all changes that are done in Senate Bill 108. And so while this directly impacts state agencies and the rulemaking process for state agencies, planners may encounter effects of this when working with DEP or Commerce or other state agencies, for example, on permits and other rule enforcement. And so I just wanted to highlight some of the key provisions within this bill to make you aware of it as rulemaking kind of rolls out for this legislative session and beyond. So one of the key changes is that once the legislature gives authority to a state agency to go ahead and begin rulemaking, it has to be done within 90 days of the effective date of the act granting the rulemaking authority. The bill went in and reinstated a requirement that an agency has to publish its notice of the proposed rulemaking at least 7 days before it could publish notice of an intended agency action. There's 2 instances where this comes up. Sometimes the legislature requires a state agency to adopt rules, and then in other instances, the state legislature, when they pass a bill, permits a state agency to enact rules. And so in the instance where rulemaking is required, if the legislature requires rulemaking, an agency must publish notice of the rule within 30 days of the effective date of the law, and then publish a notice of the proposed rule within 180 days. In the instance where this is permitted rulemaking, the rules are a little bit different. Essentially, if the legislature permits it, an agency is not required to issue a notice of rule development within a specified time frame. That jump into the next slide. Some of the additional changes that are made in this bill that I just want to highlight would be that it revises the process for issuance of a statement of estimated regulatory costs, or CERC. It allows members of the public to request a workshop on the CERC. It also limits the time frame for legislative ratification of a proposal. So once the rulemaking process has been completed, and now the rule requires legislative ratification and it goes back to the Florida legislature, the legislature has to adopt that rule and ratify it within that legislative session. If it does not do that within the same legislative session, then the rulemaking process has been voided and they have to start all over again from scratch. Couple of implications on the next slide. Certainly that you'd want to keep in mind here is that we're dealing with faster agency action, and there's going to be greater transparency with the CERC workshops. There's going to be improved access to the rule content, and you certainly want to be tracking legislative sessions to see how these rules are ratified, if they're ratified at all. As far as emergency rules goes, you're going to be wanting to keep an eye on revised emergency rule standards that could affect time-sensitive local programs relying on these state rules. And essentially, some practical tips as you implement these changes. Especially for those of you that are working on environmental and housing matters, just track these timelines a little bit more closely, certainly since they're going to be moving a lot more quickly now going forward on adopting rules. And with that, I'll turn it over to Eddie.
Yep. And just to echo what David said, I think he covered it very well. It's about tracking it. I know that a lot of our local planners administer or apply to grant, and these will fall under similar processes. So be really particularly mindful of those. And you should use the time frame that you already have established at your queue to establish regular patterns how you check for upcoming rule changes. So the upside of it, the downside may be that it's much faster, but the upside is that there are more specific requirements that you can track now. So it helps you. It should help you with that aspect there. I'm gonna turn it over to Zach now to on SB 784 planning.
Thank you, Eddie. So SB 784 platting is a really big change from previous practice in the state of Florida, which provided for all plats to be approved by the governing body. Now, an administrative approval of plats and replats is required to comply with state law, and with no governing body required. A local government must designate an administrative authority by ordinance or resolution to handle plat processing, and establishes strict timelines, 7 days to acknowledge receipt of a plat and note any deficiencies. You must approve, conditionally approve, or deny within a specified time frame. And this it also prevents officials from requesting additional time. So really what this does is removes discretion from elected bodies related to plats. It requires a formal assignment of a staff-based administrative review process, and places some additional pressure on the local planning departments to meet these deadlines. It could reduce public input or oversight over these land division decisions, although functionally, plats have been largely ministerial for many years. So there's, I think, some big changes and some not so big changes. So I'll turn it over to Eddie on what will be the practical impact.
Right. I mean, as a former community development director, I have to say, must be nice to have an in-house surveyor. Most of our departments do not, at the many cities I work with. So for departments relying on outside surveyors, I would say that with this shorter time frame, really try to work with the procurement department to consider a work order system that can be quickly implemented to meet the 7-day notification requirement, because there are times when these things are very, very slow, and you're not going to get that work order in time to do the review. There are, part of setting that up, it give yourself as much time as possible, right? Set up a pre-application review to communicate requirements to the applicant, similar to, the process with 1080, and really integrate and formulate response to your workflow for each item in 177.091 of the state statute. Be smart about the workflow, right? Utilize the phone number, day, chart each application, and so forth. Now, some application review alignments are written into your code, or either at the county or the city level, and sometimes city by reference to the county. So you may need to go back and look at the code requirements and amendments, or standard operation procedure updates. You need to designate the responsible official, and should have a detailed plaque checklist that should be submitted as part of the minimum requirement, just like you would do for rezoning under 1080. With that, we're going to keep on diving in with SB 954 with David.
Thanks, Eddie. And this is one of these bills that I certainly want to bring to your attention. It's certainly one that I've been trying to bring to the attention of city attorneys across Florida, because this is a bill that's going to require every city and county in Florida to adopt an ordinance by January 1st of 2026. And if you're outside of Palm Beach County, you're likely not familiar with this issue, and it's the issue of dealing with certified recovery residences, otherwise known as sober homes. These are transitional homes in residential neighborhoods where a person suffering from addiction can live on a temporary basis, where they receive a limited amount of guidance from staff as they try to transition from being addicted into a regular world. And there's been a proliferation of these in Palm Beach County. And so that's kind of been the epicenter of the recovery residences in Florida. However, this bill now has application to the entire state. And so therefore, it's one that we wanted to highlight and bring to your attention. And like I mentioned earlier, this bill is going to require that every city and county in Florida adopt a local ordinance establishing procedures for the review and approval of certified recovery residences. The deadline for adopting that, again, is January 1 of 2026. And when you go ahead and start adopting those ordinances, there's a couple things to keep in mind. First of which is that your ordinance is going to have to establish the procedure for approval of the residences. The ordinance is going to have a process for what is known as requesting a reasonable accommodation. And this reasonable accommodation comes up because when you're suffering from addiction, that is something that is protected under the ADA. And under the ADA, you're allowed to get reasonable accommodations. And so if you have a land use ordinance in place that places a restriction on the establishment of a certified recovery residence, you now have to include in your ordinance a reasonable accommodation to be exempted from following that ordinance, so that you could accommodate someone that is suffering from one of these ADA protected reasons. So, you know, some couple of pointers here to keep in mind, again, as you adopt these. The ordinance has to be consistent with the Fair Housing Act. You're going to have to establish a written application process for the reasonable accommodation. And then when you get these essentially applications coming into your city or county, you're going to have to date stamp these applications, and there's going to be timelines in place. Essentially, you're going to have 60 days after the receipt of a completed application to either approve it, approve with conditions, or deny the request. And you're only going to be able to use evidence-based reasons and identify any deficiencies or actions necessary for reconsideration. So certainly, you know, one of these bills that you're going to want to keep in mind and work with your city attorneys and helping them identify the issues that come into play when adopting a new ordinance to allow for the establishment of certified recovery residences within your jurisdiction. And with that, I'll turn it over to Eddie.
Thank you, David. Now, as the planner, Dave covered a lot of really great points. I'm going to add them, just minor some aspects that you think about how you administer this from a planning standpoint. You have to treat the certified recovery residents as residences, or not businesses, as I found some folks have tried to do, purposes of zoning. And you still can consider a spacing requirement as you go through this. Definitely maybe consider the adopting process procedures on application intake with the high limitations built in. You know, important here is to avoid using restricted definitions in family and drafting any code provisions, and definitely work with your city attorney with that aspect. And last but not least, you can't really require additional public hearings upon beyond the minimum required to grant the request accommodation. You are very limited in scope. And a lot of it is also rooted in Fair Housing Act, where you know, a household with two or more persons with disability can choose to live together. And for the purposes of how this act is interpreted, the status of being in recovery is considered a disability under that and under ADA Title II. So planners working on these ordinances to be mindful of that before you even go to your city attorney's office, so you can kind of get through the process a little quicker. With that, we're going to go to HB 683, synthetic turf. Zach?
Thank you, Eddie. So HB 683 is dealing with synthetic turf. It prohibits local governments from banning or inconsistently regulating synthetic turf on single-family residential properties that are less than 1 acre. It requires prompt action on change orders submitted by contractors for public construction projects. Likely you in the planning department will not see this, but it is one of the functions of the bill. It blocks local governments from requiring building permit applications to submit copies of contracts or profit statements. It expands the private provider authority for inspections and plan reviews, and adds exemptions from the Florida Building Code for spaceport-related equipment. This is most analogous to the exemptions we see related to the Right to Farm Act and agricultural structures. So that is the core function of this bill. I think the planning audience, you all are going to be most interested in the synthetic turf on the residential properties, and the regulations that you all are allowed to enact in your local government. So this will have the effect of preempting local landscape standards related to synthetic turf. It obviously requires these faster review and approval of contractor change orders, which you all most likely will not see. It limits building departments' access to financial documentation and increases reliance on private inspections, which really is kind of a government by government impact. Some may be using already private providers quite a lot, and some may not be familiar. So with that, I'll move over to Eddie.
Thank you, Zach. Now, when I first heard synthetic turf at a local council, I'm not going to say which one, they were discussing the item because the residents had a lot of concern about environmental factors. When you think about these rules about defining synthetic turf in your code and covering everything, the way the statute is written, the bill is written, doesn't really allow you to kind of visit on that basis because it's covered under the rulemaking by DEP, which will define what material can be used. So you need to think about how to put synthetic turf in your code as a planner. Really consider focusing on the rules on permeability, block coverage, and on-site and surface water retention over these other considerations, even though they might be the priority within your commission. Not that you don't address them in presentation, but because of how the statute is written, it's really important to note that critical distinction of what you can and cannot do. And be very mindful of prohibited regulations of overall site condition. Because the rules are still evolving, you should review DEP proposed and adopted minimum standards, including permeability for their for those synthetic turf products during the review making process, particularly because we know synthetic turf products are not all the same in that regard. And with that, we're going to talk about I talked about environmental, so it's a good segue into HB 733. I'm turning over to David to start talking about brownfields.
Thank you, Eddie. And so House Bill 733 made some changes to the brownfields program in Florida. I think one of the most important things that this bill did was that it removed the requirement for local governments to map institutional controls. It allows property owners and developers to propose brownfield area designations now. And then it authorizes the entry of Superfund sites into the brownfield program before site cleanup is complete. It reduces the procedural barriers for obtaining a no further action status on partial sites. And so certainly some key changes that kind of come up in this bill. As a practical tip, as you start to implement this bill, this is probably a chance to re-engage on dormant or stalled brownfield areas. You may want to work with your jurisdictions to evaluate whether current or past brownfield areas in your community could benefit from the expanded eligibility or cleanup flexibility. And then you certainly want to work on removing any outdated mapping requirements from your local policies to incorporate the changes that House Bill 733 incorporates now as it relates to mapping for brownfields. And with that, I'll turn it over to Eddie.
All right. All right. Um, Thank you, David. Now, the requirement for mapping the data is removed, but it doesn't really preempt you from having local requirement for tracking. So you can still continue to track brownfield. And this change doesn't really actually remove any consideration for future land use elements where you should be evaluating these properties and including that in your policies in the flu. So, I mean, while these changes, I would say with planners, don't really do anything different because you still need to report on it. What there is a benefit here is that you may have large sites within your community that are under existing agreements, or where you're trying to work through and say, how can we clean this up? This act allows us to break up those sites so that you don't have to wait for the entire site to be considered really cleaned up in order and to build on it. It allows for parceling of a different aspect, and it does do that for existing agreement as well. So it's a way to try to move some of the things that maybe held up a little bit more when you reviewed it a little bit further. And then last but not least, our deep dive is the portion is Senate Bill 582, unlawful demolition of historic structures. And with that, I'm going to turn it over to Zach.
Excellent. Thank you, Eddie. So SB 582, unlawful demolition of historic structures. So this authorizes local code enforcement boards and special magistrates to impose higher fines for illegal demolition of historic structures. These structures must be on the National Register of Historic Places or be listed as a contributing structure in a registered district. Fines may exceed the normal statutory limits, but they cannot surpass 20% of the property's market value prior to demolition. And the demolition must be willful, knowing, and not due to a natural disaster in order to qualify for this enhanced penalty. So moving on to the implication, this is really a good sign from the legislature as far as encouraging stricter protection of our historic resources. It does require our local court enforcement boards or magistrates to assess both valuation and intent if one of these violations is brought forward before the board of the magistrate. And it does empower our local governments to have a strong deterrent against unauthorized demolition that aligns with preservation goals. So now I'll turn it over to Eddie.
Right. And thank you, Zach. As Zach mentioned, really it is a tool to help preserve historic buildings, right? Particularly when we have see issues that planners saying about demolition by neglect. Like we were discussing with the other piece of legislation, this only applies to the National Historic Register in this case, and the listing in the Florida Master Site file site is not the same. So you should really check and go through the designation of all the properties you want to protect. Going to that checklist from the Secretary of the Interior standards and guidelines that is needed, and so forth. You should also really work with your building department. Sometimes they're with the planning department, sometimes they're not, right? To establish guidelines to review for historic structures in particular, added by SOP or ordinance, because the critical word in this piece of legislation is it has to be approved. And so if you don't coordinate your building department and they approve it, guess what? It's been approved. So it's really important to link the zoning and the building functions in this case. I would do so by beginning to maintain a database of all historic sites and sharing that with the building department and coordinating and updating with property appraiser data annually as well. The last important part is that for this particular bill, it does provide for additional penalties. But I worked in a city where the code had a maximum limit to anything from the magistrate. And so you might have to go back and change your code if they have the maximum limit. You might have to anchor maximum penalty clauses in your land use element or historic preservation element to really provide that justification a little bit further as a planner. I would also consider adopting regular review period or condition to demonstrate willful and knowing, because you're going to have to have a case file that says that, particularly when you either send planners or code enforcement officers out there. And of course, there's an opportunity here to leverage other tools such as tax credit and even requiring those regular review periods. Don't be afraid of plan to really write those rules and leverage those tools. Um, it's a really important aspect because we do see demolition by neglect, and it does happen. And this is meant to design to hedge against that, but only if you apply it right, right? And then we're not going to go into depth in these, but we have some final additional bills to know. Some of these are going to be covered in more in depth in future webinars or at the conference, generally covering transportation. Really happy to note that HB 85 has walking conditions deal with safety for school children and expand criteria for identify hazardous walking conditions. Um, that passed unanimously. That took effect July 1st. There's a lot of different items with the transportation bill, particularly 462 and 1660, Senate Bill 1662, that we'll talk more about the conference. It had to do with operating MPOs, having LRTP include considerations of natural resources. But importantly, and this will affect your local government ordinances too, it amends the definition of micromobility devices and motorized devices. As you may be aware in the past, that was really just tied almost exclusively to bicycles, and this actually adds an additional layer that you should be aware of as we discuss these at local government. It does also change the authority for the local governments, county and cities regarding regulation of electric bicycles, including on sidewalks and so forth. And we will cover this more extensively in the next workshop. Similarly, with 1662, there are various definitions and so forth, and it actually also repeal provisions regarding high occupancy vehicle lanes. Uh, there are some state level planning that isn't going on in place, whether it's about spaceport or vertiport. We'll probably do a series on that later from APA and so forth. That this Senate Bill 1662 really sets up the thought processes for moving forward. Uh, Another bill to be aware of to review a little bit further is Senate Bill 1228, which regulates the use of reclaimed water. And how to amend the plan to incorporate reclaimed water project identified in an outstanding Florida Springs recovery or prevention strategy. Certain parts of the state should also be aware that House Bill 481 restricted anchoring in certain Florida waterways as well. Lastly, on the minor bill, House Bill 443 is education. This is a very specific rule that also goes back to 1080 as well that we discussed earlier. It defines charter schools as public facilities for concurrency purposes. This is really important because, one, we generally write very broadly as planners sometimes about public facilities. So including charter schools in there may have some nuances that you will have to work through within your code or your comprehensive plan. And so I would definitely recommend that planners go back and look and review those specific requirements. In addition, if you work for a school district or you work on impact fees, this affects the way you might think about concurrency, and by extension, because you have to look at the rational nexus and the proportional aspect. Now we're thinking about how the fees are calculated, right? So really, just I would recommend you take a look at that revised definition and incorporate that if you're working on an impact fee for schools or you work in school planning, because it definitely had an effect, and you have to connect what you see and the revised rule for Senate Bill 1080, which also has limitation on how much you can increase fees, with how we're redefining charter schools as public facilities for concurrency purposes. Now, before we go into Q&A for a couple of minutes, I want to note, join it for that, again, that this is the first series of three. we have two additional upcoming discussions. The deep dive at the conference is going to be on Thursday morning at September 16th. We'll cover transportation, school planning, and housing. It's going to be two CM units or one law CM unit for those with the AICP. And for deep dive next step, we're going to have an additional webinar that's going to cover some other pieces of legislation that we didn't cover today, ranging from rural land to housing, including House Bill 700, annexation, environmentals, including mitigation banks, beaches, and more. The link is here if you want to register for that. We hope to see you there. Um, and this is our contact information. Feel free to reach out to any of us if you want more clarification, or want to dig a little deeper in something that we said, or you have questions about the slide. And as the president-elect for APA Florida, I really appreciate you all joining me this morning as we talk about these pieces of legislation that have a lot of impact for our day-to-day as planners within the state. And with that, if you want to type in your Q&A, we believe we have a couple more minutes for Q&A, and we're happy to stay on and try to answer some of those.
Eddie, our panelists have been answering questions as we've been going along. About 22 questions have been answered, but a couple I think might benefit the overall audience, and we will send the answers to the questions after the event. But there was a question early on, and I don't know who to address this to. It says, I have heard FDEM legal may be working with the legislature's legal to revisit the cumulative damage prohibition. Do any of the panels have insight into this? I think it was regarding SB 180.
Well, I may defer to if the folks from MHD. I don't know if Anna Grace, you've heard it. If our folks in Tallahassee have heard anything, I certainly have not. So this is something that we will explore a little bit further and try to get you an answer if we hear anything. Definitely something that APA Florida had a legislative policy committee, and so this is going to be on our track list.
There was a question regarding 1070. You mentioned that if a commercial use is allowed by waiver or variance, it does not make the zone mixed use or for live local purposes. What if these commercial uses are allowed as conditional or special exception uses?
Well, from a plan perspective, what I already see in the statutes for the changes is the commercial uses themselves are specifically defined. Though it's not defining things as commercial or industrial or a different name for the zone. It's actually defining for the uses. So as far as applicability, and I'll let the attorneys on the call handle this a little bit more. If it, from a planner's perspective, if it walks like a duck and it quacks like a duck, it's a duck. So the distinction there, I think, is probably difficult to kind of parse out, given how specific the wording within 1730 is. I don't know, David, Dak, if you have anything to add to that, but I believe folks have a handout in the very, or actually not the handout, but you reviewed the specific, almost at the beginning of that piece of legislation, 1730. It had very specific definitions. Dak or David?
Eddie, I think you kind of hit the nail on the head here. I don't know if I necessarily could opine on it any further. I'd happy to do a deep dive offline though. And if you want to reach out to me, my email address is on the screen and I'm happy to look into that a little bit more for you.
This is a question about the synthetic turf. I'm not going to read the beginning because they quote the state statute, but it says, can a local government ban synthetic turf between now and the adoption of FDEP standards? It seems like the synthetic turf provisions are not effective until the standards are created.
Zach, you want to handle that?
Yeah, I guess I would say in the context of SB 180, there's a prohibition on more restrictive or burdensome land development regulations. So a ban on synthetic turf may or may not fall into that, right? Most likely, I would consider that more burdensome. And also, I think you want to consider your allocation of resources, uh, right? Why would a local government, if there's a preemption coming that will invalidate your regulation, why would you expend your resources to do something that is going to be reversed in a matter of months? I think that's really
Yeah.
more of an allocation of resources question.
Right. And as far as the bill is constructed, there are, I believe, specific portions there where you are not allowed to prohibit on the basis of single family residences and that zoning already. And because while the definitions are still forthcoming from DEP, that administrative rulemaking, the bill itself and those other clauses took effect July 1st, so they are actually in effect now. So it's not like if you wait until DEP passes that rule on what qualifies as synthetic turf, that other rule isn't already effective and you're grandfathered in. So kind of, I mean, that's the way I'm looking at it from a planning perspective. I don't know if how our lawyers feel about our legal counsel feel about that, but
I would just add briefly, Eddie, that I think my understanding is that DEP has already commenced the rulemaking for the synthetic turf, and so it's already underway.
they have, from my understanding as well.
Okay, the last question, and again, we'll send everybody the answers to the previous questions. Housing is destroyed by flooding. The municipality can't require code changes in reconstruction. Will this affect insurance?
It, it's a loaded question, but generally our understanding of, and I'll let Zach jump in after this, our understanding of insurance is that if something has happened and there's a chance it's happening, it raises how you judge the risk profile, right? And insurance, for many, many instances, it's really your rates are really looking at things that have happened, what they've had to pay out, how to keep the fund solvent, and of course, an assessment of your potential future risk. So, absolutely, if you're rebuilding something and it's prone to destruction and you haven't done things to mitigate that risk, then the expectation might be they'll have to pay out again in the future. From a rational standpoint, that's how insurance company might think about it. So yeah, I would say that would be rationale to raise rates, right? You've had to pay it out, you may pay out again, and they haven't done anything to do anything different to mitigate that risk. Zach, you were
Okay.
gonna.
Yeah, I mean, I think, Eddie, your analysis is pretty spot on. Obviously, we don't have a crystal ball here. So this may be an unintended consequence of one of some of this legislation, or maybe we'll get lucky and there won't be any major storms in the next couple of years. We, so I
Yeah,
think we
in
just
an ideal
don't have the
world,
crystal ball.
I would say, the FEMA 50% rule would require you to build to current code. And so ideally, the new structure that's being reconstructed is going to be meeting current codes. It's going to be elevated and it's not going to be destroyed a second time. So hopefully that would lower insurance premiums. However, the preemption in 180 preventing the look back ordinances of local governments would, circumvent that to an extent. And so somebody could certainly, get around the 50% rule in a way.
I'm going to sneak in one more question. I'm sorry. This is regarding 1080. It says, how is the legislation defining completeness?
So the legislation itself does not define completeness, um, but a local government is required to post what documents are required for completeness. So you get to choose your own adventure, so to speak, but be very mindful in developing that list that gets posted to the public, because if you ask for 10 things and they give you 10 things, you can't later ask for an 11th thing and tell them that it is incomplete.
Yeah, and there are penalties for that have been snuck in other areas as well that relate right back to that.
Okay, that's it. Thank you.
Well, thank you for attending, and thank you to to my fellow panelists for their time. We hope to see you at the future workshop. And again, if you have any questions or want to discuss further, we're all ears and happy to help. With that, have a wonderful rest of your day, and thank you again for attending.